and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
Better get yourself a lawyer. Get David Whiting. He is here to provide you some free legal talkback. Good morning, David.
Good morning, Raph.
Shall we leap straight on into it?
Why not?
Let's do it. Rewa is in Endeavour Hills. Rewa, what is your query?
Hi. Around in April, we contracted someone to come up and install some roller shutters for us. After several weeks of getting kind of vague responses on when he will come and install these shutters,
Yes.
we about 10 weeks after of not kind of hearing or getting a reliable install date, we kind of opted and said, we kind of reached out and said, listen, if you're unable to get the product, that's fine. Can we just get our 50% deposit back? Because then we'll just go elsewhere and get them installed.
Yes.
He then replied back saying he can cancel the order and minus his costs and his time. He never really disclosed what that amount is and what that percentage is.
But I can't imagine that it would have been very high because it doesn't sound like he's even ordered them.
Well, it doesn't sound like that, right? I did write a letter of complaint to him, and I provided two.
So where are you at now, Reva?
With him?
Yes.
At the moment, I haven't heard anything back. He hasn't disclosed how much his time or the money.
So Reva, my view would be, you would be entitled to the whole of it. So start
again. He would
again.
be entitled to the
No,
whole
you
of
would
it?
be entitled to all of your money back because it doesn't sound like he's done anything.
No, he hasn't. He believes that his time on the order is worth something. Again, he hasn't disclosed what that amount is, and he's holding that.
Yes, I can't imagine it would be a great deal of money though. All right. So I mean, I would be pushing for all of your money back. How much have you spent, Rewa?
It was $5,000.
Is that was the deposit, was it?
That was the deposit.
I suppose my worry, Rewa, is that the person you're dealing with doesn't sound particularly reliable. So I'm a little bit anxious about how much of the $5,000 you're going to get back, as to whether he's around or not around. But certainly, I would be considering issuing a claim at VCAT on the basis that they didn't deliver on their promise, and you want the money back.
That's it.
Okay.
That's how I would be going. Yes.
You don't feel like he's entitled to a portion of that money then? You agree?
Well, the answer would be nothing he's done is of benefit to you, and he hasn't delivered in a reasonable time. Your argument would be that the consideration for the contract has totally failed, and you want your money back.
Good luck, Rewa. See if you can start there at VCAT. Good luck. Mary Louise is in Glen Huntly. Mary Louise, what's your query?
Good morning. We received advice that our large OC committee can self-regulate. So to reduce the overall volume of emails, the majority of the committee voted that you can vote no to a motion, you can vote yes, but if the majority doesn't reply or object, then after 14 days the motion passes.
Sorry, and you use the word, forgive me, you use the word OC, that's Owners Corporation. This is an Owners Corporation issue, isn't it?
Apologies.
Yep. No, that's all good.
Right, yes.
Okay.
So
I knew what you were talking about, Mary Louise. Yep. The issue is there's a principle in the Owners Corporation rules about what are called interim decisions.
Yes.
So, and an interim decision is if it doesn't pass it passes, but not by the required majority or with the required number of votes, it stands as an interim decision unless there is...
Sorry, Dave, can I interrupt? This is not interim. This is just regular email motions that are posted out. Not meetings, decisions. It's just regular business. It might be that somebody...
Well, then the general proposition, Mary, is that Mary Louise, it's the number of people who vote that count. Non-voters aren't considered to be opposed to the resolution. So if there's 15 people in the Owners Corporation and 3 say yes and 2 say no and 10 say nothing, it gets up.
Okay. So we haven't basically breached the spirit of the Act by saying if you don't participate, you generally you agree
you get ignored.
with the proposition.
No, but you get ignored.
Yes.
Yeah.
Okay.
But it means you can't complain about the decision.
Is there anything in the Act that deals with this, like a bit of the Act that we could look
There
at?
isn't a piece of legislation that talks about apathy. There is a piece of legislation that you need to look at it and talk about majorities and decision making.
Yes. And
Okay.
we've made it very clear when we send a motion out that if you don't want to reply, you'll be taken to be agreeing with the motion.
Well, no, not agreeing with the motion.
Or you don't
Agreed
object.
with the outcome reached by the people who vote. So
Yes,
if you
yes.
say to somebody, this is the resolution, if you do not respond, you will be considered to have voted yes, it's just wrong.
And she's doing the right things, isn't she?
She's turning around and saying you will be bound by
Yep.
the decision of the people who vote.
Yeah.
We are recording their votes as did not object, and the motion passed.
Yes, but
that
you're
good
voting
enough?
for and against.
Yes.
And the other ones did not vote or did not participate. What you're saying is, I require a no or a yes. And if you don't say anything, I'll treat you as a yes.
So, David, is it okay for the minutes to simply say these people voted yes, these people voted no, and others did not
didn't
vote? Did not
Yep.
vote. Just say did not vote.
So it's
Don't say
passed.
did not object. Say did not vote.
Did not vote. It's passed on the voices.
Okay?
Thank you. That's
No
very
worries. Good luck, Mary Louise. Thank you for your call. 1300 222 774 is the phone number. Bob has dialed that number from Beaumaris. Bob, what's your query?
Recently, my beautiful son decided to have a motorcycle accident and die. So my friends, who's a lawyer, said get together all his papers and go to see a fantastic lawyer. In order, he doesn't have a will that I can see, and he doesn't have any papers that I can see. All he's got is a laptop, and then someone else
life
said,
is on the
"Listen,
laptop,
You
is it?"
can't open a laptop.
Why can't you open the laptop?
Well, that's it. I don't have his. I'm
Password
I'm a
protected.
bit of a technophobe. I don't have his password. I've got the laptop, but I just don't know what step to take. Someone said you're legally not allowed to open somebody else's laptop. I've got his death certificate,
Sorry, Bob.
but yeah.
Who did he leave? Did he leave a partner and children?
No. He had a partner, but a very short-term partner, possibly just 12 months cohabitation and no
Right,
joint
yeah.
bank
So,
account.
okay.
He's
So
left
no
his grieving dad is what he's
dependents.
left,
There's just mum and dad, is it?
and a brother.
And a brother. Well, you and his mother are entitled to the whole of his estate. You are entitled to administer the estate. You could start the process of administration. So I would start with his employer. Now, his employer will know where his pay went to. The employer will know where his superannuation went to. That gives you a bank and a super fund. There may be an insurance policy connected to the superannuation. So that's where I would be starting the process. The lawyer that you're going to will be able to recommend someone who can look at the laptop to see what could be taken from it. There are a number of organisations who do forensic audits, generally ex-police officers who do this for a living. They should be able to get into the laptop.
I just don't have any trust anymore because silly guy, he's 30, he's died, he's not supposed to. I gave him the motorbike. I don't trust giving his laptop to someone, but I just don't know which way to go.
Well, then ignore the laptop and deal with the bank and the employer.
Is
the
he
bank and the
obliged to look at,
superannuation.
as the executor, is he obliged to look at the laptop?
Well, he ought to be doing what he can to properly administer the estate. Or alternatively, Bob, do nothing. I mean, you have the right not to be involved if you don't want to be. But if you're going to be, if you're coming along and say, I'm going to do part of it, then you pretty well have to do all of it.
Okay, Bob, does that begin to answer your questions?
That's good.
Okay, no problem.
Thanks,
Good luck,
Bob.
Bob. Sorry to hear about that. But thank you. That's a sad one, but interesting situation to be in. Exactly what David Whiting is here for. Lisa is in Langwarrin. Lisa, what do you want to mention?
Good morning. I'm just wondering about statutory limitations with insurance company. My husband was involved in a car accident 3.5 years ago, and both parties have the same insurance company. So we just left it up to them and didn't claim there was very little damage to his vehicle.
Yes.
And then forgot all about it. And then yesterday got an email asking for the excess,
So did your vehicle get fixed or not fixed?
not fixed.
So you never made a claim, or did you make a report?
Just made a report.
And is it was your husband at fault in the accident?
Well, this is why we left. It was one of those that who is actually at fault. So we just left it up to the insurance company. We thought, well, we'll report it
Yes.
and leave it from there. And then they've come back and asked us. We've had no contact at all from them, nothing for 3.5 years.
Okay, they're finally getting their paperwork right. Limitation period is 6 years, Lisa.
Okay.
So if you, in fact, owe them money, they are entitled, well, except I want to know a little bit more before making a decision for you.
Yeah.
I'd want to know what the cost of repairs to the other vehicle was. Because, I mean, let's say your excess is 1,000.
Yeah.
The repairs might have been 5,000. So if it's your fault, you pay the 1,000 and you move on.
Yep.
If you say, I didn't make a claim, I'm not going to make a claim, then you might get back from your insurance company advice that you owe them 5,000. And then you've got to work out who's responsible. So your next question ought to be, how much was the claim?
Yeah, to the insurance company, how
Yes.
much the other
Yes.
person's obviously claimed.
But you haven't made a claim, so technically you don't owe the excess, but it may be that you're liable for the damage to the other vehicle.
Okay.
And can Lisa, 3.5 years later, can you or could
they will
Lisa
have all the
object?
paperwork because
But can Lisa say, we don't think it was our fault, or that it's too late to do that?
Well, I think that was her starting proposition 3.5 years ago. It's not my fault, but under the terms of my policy, I've got to tell you about it, but I'm not making a claim.
Fair. Lisa, does that answer your query?
You've got to make up your mind whether it's a claim or not a claim, Lisa. And if they've come to you and said, I want the excess, then maybe it ought to be a claim, but start with what was my how much do they want from my excess, and what's the cost of repairs I'm now avoiding?
Okay.
The other party.
Yes.
Yep, I understand.
Good luck.
Thanks for your advice. Thank you.
Thanks a lot, Lisa. 1300 222 774. If you've got a legal question for David Whiting, give us a call.
I'm gonna die before they build the airport choo-choo.
Melbourne Airport CEO Laurie Argus, was it the Melbourne Airport choo-choo song that changed the airport's mind?
Absolutely.
Breakfast with Sammy J.
Any train is better than no train, so we've made the compromise.
You've said by 2030. Can you guarantee it'll be built and completed before the end of my lifetime?
Well, I would be hopeful.
Start your day with Sammy J.
Weekdays from 5:30
on 774 ABC Radio Melbourne.
This is ABC Radio Melbourne with Raf Epstein.
David joins us every Tuesday on 774, just trying to answer some of your legal and consumer and divorce law and other sorts of quandaries. David Whiting is answering calls, this time from David, a different David, in Camberwell. David, what's your query?
Hello, David.
Yes, good morning. I'm wondering what the procedure is if there's probate and there's very few assets, like $30,000, no house, no...
Why are you getting probate, David?
No, I'm wondering, do I have to get probate?
It really depends upon who has the asset and what their requirements are. Now, normally, if the estate's less than $50,000, you can do an informal administration of the estate. So let's say it's, two bank accounts with the same bank. You say to the bank that either the person left with no will, or alternatively...
The person's left the will to my wife as the executor and
the sole beneficiary.
Yeah.
Okay, then she writes to the bank, or someone writes to the bank on her behalf and say, here's the will, here's the death certificate, this is the only asset, can I administer the estate informally? And the general answer will be yes. They will ask your wife to sign an indemnity that says if someone comes along with a stronger claim, or that we pay you by mistake, or something like that, then you promise to give the money back. That's the process.
Okay, so this informal administration is just you write them a letter and say, let's go.
With the other bits and pieces, yes. But it's yes. Yeah, the answer would be, he's my son, my brother, my cousin, whatever it is. I'm the sole beneficiary. Here's the will. Here's the death certificate. I want to administer the estate without getting a grant of probate.
Okay.
Now, if it's over 50 grand, they will require probate. I've got one at 51 where someone wants probate. But at $30,000, I don't think you're going to have a problem, David.
Good luck, David. Thank you for your call. Parsh is in Wheelers Hill. Parsh, go for it.
Hi, good morning. My question was around town planning. I've engaged a draftsman, a town planner, to help me with a subdivision application. Received the council permit pretty quickly. He did a good job for it. But then the engineering drawings looks like he's subcontracting that out to someone else. And for the last 6 months or so has been stuffing me around by saying, oh, they're ready, I'll have them to you tomorrow. And
so you've got a planning permit to allow a subdivision. You've now got to go off and do the works. Is that right?
I've got to get the engineering drawings so that I can get the building permit. And I'm not getting the engineering drawings from him.
Oh, so this is a town planning in connection with a building as opposed to town planning in connection with a subdivision?
Well, it's a subdivision building. So it's basically a 2-lot subdivision.
Okay, all right.
Which will, yeah.
Yep, all right. So why would you just not fire the person who's organising it for you?
Well, this is... One, I've paid him in advance so that I can get the engineering drawing. So I could fire him, but I don't think he's going to pay me back. I've asked him.
Well, it's kind of like our first caller today. Pash, what you would do would be ask somebody else for the cost, what it's going to cost to get the work done, to get the drawings done for the work that's required. And tell him that in the event that he doesn't complete the task within a defined time, you will hire someone else and seek to recover those costs from him.
And would the process be the VCAT application to recover the
costs? It would
costs?
be a VCAT application, and what you're really saying is that he hasn't done the work properly, as a result of which you've incurred another cost. Here it is, you want him to pay you.
Sure, and one last bit. If the cost is greater because the new person has to redo or reevaluate some of the original application
Pash, I would be surprised if the cost wasn't higher. So you're talking about a job that you engaged this person for 2 years ago. I would expect that the cost will be higher. That's your private draftsman's problem. He's taken on the job of organising all of these skills and he's failed or is currently failing. You give him a time frame to complete. If he doesn't, you hire someone else, but you tell him that you will seek to recover from him the costs that you've incurred.
Okay.
Thank you very much.
Thanks, Pash.
Good luck, Pash. It's 23 after 10. Greg is in Brighton. Greg, what's your problem?
Hello.
Hello, Greg.
You're on air, Greg. Go for it.
Yeah, thank you, Phil. Taking my call. Wife and I bought a townhouse last year, about a year ago. The insurance premium seemed rather high. In doing some due diligence...
I'm sorry, what insurance premium?
The building insurance, the Owners Corporation insurance.
The Owners Corporation have insured the improvements, yes, okay. And when you thought...
insured the building, actually.
Yes, yeah, well, the improvements on the land, yes, the building.
Yeah, beg your pardon. Okay, so in doing due diligence, we asked questions and then came across AGM minutes which said a list of defects which has affected the insurance premium has now been solved. But that, in fact, is untrue. There are defects found by
are they the same defects or different defects, Greg?
These defects, I gather, were established because the original owners thought they'd take action against the builder, the developer.
Right. So what's the issue, Greg?
The issue is I'm seeking an answer whether I can take action if the AGM minutes pointed me in the wrong direction. They may just be an error, but they could be a fabrication.
Yes, but Greg, you haven't told me that the AGM minutes were wrong. Because let's say there were 6 items listed in the AGM minutes, and yes, they're all dealt with. And then when someone's come along and found another 5, well, they're not the same list. And your claim might well be against the Owners Corporation rather than the agent, unless you're suggesting that the agent knew something different.
Yes, I don't think the agent knew any different, so I'm relying on the AGM minutes.
Right, then your action might be against the Owners Corporation, but part of your case is to prove what they knew when they held the AGM.
Okay, thank you very much, David. That's clear.
Thanks, Greg.
Thanks, Greg. I've got a frog in my throat, but we'll get Con in Clayton while I clear my throat. Go for it, Con.
Hello.
Go for it, Con. Well, how can we help you?
I've got an issue. I'm in the process of changing from one lawyer to another lawyer because the current lawyer did things incorrectly, cost me quite a bit of money due to errors and delays. But he's not handing over the file until I settle the final bill, which I don't have yet. My question is this something that he can do? What if, because he knows now that I need the file from him to go to the new lawyer for a hearing that's coming up in the next few weeks. So,
Con, the lawyer has, at law, the lawyer has a lien, which is the right to retain possession of something until the lawyer's fees are paid. Now, that doesn't mean that you need to finalise your dispute with the lawyer. It just says, if it was me and you owed me $10,000, you want to go and see another lawyer, I'd say, yeah, sure, that's fine, but you've got to pay me. So,
does that make sense, Con? We've got two. We've got two
coughing people in this room.
Yeah, we do. Does that make sense to you, though, Con?
it does, but if I want to then can I take action against him for what he's done?
Yes, you can. There are a couple of issues, but you could make a complaint about an error made by the lawyer. You can take that to the Legal Services Commissioner. So you have how much are we talking about, Con?
Look, I'm not sure what his final bill's going to be, but we're already up close to 50K in fees.
And it's not a small claim, but you should consider making a complaint against the lawyer with the Legal Services Commissioner.
Okay.
Thank you.
No worries. Good luck, Con. David Whiting and Raph Epstein with you, both trying to clear our throats, but that's okay. We'll make it through. Candice is in Gisborne. Excuse the froggy throat. Candice, go for it.
Hi. My question is around contracts, I guess. So what happened is I had paid for some curtains to be made, and at the time when the guy came out, I had a verbal discussion and agreement with him about how the fabric was meant to be cut. It was some months later when I actually paid for the curtains to be made, and the direction that he put on the contract was the opposite to what we had asked. I didn't realise that because I didn't recognise the terminology, and so it's they've come and the fabric's cut differently to the discussion. But they're saying because I've signed that contract, that I'm at fault.
The general proposition, Candice, is that after negotiation, whatever you reduce to writing is what you agreed upon.
Okay. And is there, so if it is using a terminology that you wouldn't normally expect a lay person to know?
Like what, Candice?
So it is a fabric term and it refers to the pile direction, whether it's cut up or down.
Yes.
And it just said pile direction up. And I don't speak fabric, so I didn't actually realise what that meant. No. I just assumed.
There's two other people in here nodding. We don't speak fabric either, Candice.
Yeah. So I'm just sort of wondering, so there's no, if you sign the contract, they've made a mistake, it's your responsibility. There's no getting out of the contract?
Let's do it this way. They made the mistake first and then you signed the contract. I don't see that you get out of the contract, and your starting point is, does the person who you negotiated with acknowledge that he made a mistake during the negotiation?
He acknowledged that he remembers the discussion, but he didn't put it in his notes, and he assumes that's because I was indecisive.
Okay. So you're going to have to prove that it was his representation that you relied upon.
Yes.
Yes. It's a matter you could take to VCAT and you could say, we had this discussion. I was adamant that I wanted the pile down and his notes weren't adequate and I didn't know what it meant. But what language did you use in your discussion that doesn't equate to fabric up or down in fabric?
Well, it was, he said to me, when I've looked it up since, but I said I wanted the fabric to look shiny and luxe.
Oh, yeah.
Yes.
So I was quite specific about how I wanted it to look. And now I know.
Okay, so he used different language. I understand, right? Yep.
Yeah.
Okay.
Yeah, sorry.
So like velour curtains, is it? Candice?
How much is at stake, Candice?
Not a lot. It's only $1,000, but it's a lot to me.
Yeah, I understand.
Okay. Right.
Yeah.
So you're going to have to put a fair amount of time in, and what you might do is see if they can do a deal.
I have approached them because they actually they measured them incorrectly as well.
Oh.
And they've come back and said they will fix the measurement, but they won't.
Won't fix the look.
Won't fix the look. But I'm just a bit...
It's still a VCAT matter if you want to take it there, Candice.
Okay.
You used one set of words to describe the look that you were after.
Yes, and when I went in and paid for the quote and I checked with the girl and she said, I don't know, I work in blinds, not in curtains. So I thought...
Right.
She doesn't speak Arabic either. Look, good luck, Candice. Your options are VCAT, and I appreciate $1,000. It can be a lot. I guess that's just a decision you will have to make. David, you have no homework.
I have no homework. And I won't see you next week. I'm taking a week off.
We'll
be back
allow
the week
you
after.
to do that.
It's so kind.
David Whiting is here answering your legal questions every Tuesday. Somebody else will be answering your legal questions next Tuesday.